First is Mr. Anuj Prasad, the alumni of NID and the co-founder of and CEO of Dismania, a leading design firm established since 1993. Over 30 years of industry and entrepreneurial experience. He has pioneered designs as a strategic tool for a value creation across industries for product design and automotive innovation. Next is Ms. Shalini Goyalji, the director and brand custodian at DesignWise India Private Limited, an expert in brand strategy and intellectual property management. She leads the company's marketing, distribution, and promotional initiatives. Our third panelist is Ms. Nishtha Sharma ji, a research program coordinator at the Center of Innovation, Intellectual Property and Competition, CIIPC, National Law University, Delhi. She plays a key role in research, education, and outreach in IP laws and also coordinates with WIPO. The major concern today is AI. AI जिसके बारे में मोदी जी भी बात कर रहे हैं और अमित शाह जी भी लगे हुए हैं. Everyone is working on it. So let's start with Mr. Anuj Prasad ji. As a visionary in industrial and automotive design, how do you envision AI revolutionizing the very fabric of product innovation and prototyping? Will AI be a contributor or a disruptor in the creative process? That's a very concerning question, sir, क्योंकि अब तो पहले सिस्टम बिठाना पड़ता था, आपको ऑफिस लेना पड़ रहा है, स्टाफ लेना पड़ रहा है, there is a concept, डिजाइनर्स हैं, इक्विपमेंट्स हैं, कंप्यूटर है, अब एक AI है.
ये सिर्फ एक AI नहीं है, ये सारी चीजें भी हैं उसमें. So AI is actually just a tool, you know. I think we have made a very big hype out of it because when the aircraft was made 100 years back, this massive technology, you know, which made many things redundant, whole lot of transportation. What it gave you was agility of transportation. You know, you could actually travel faster, reach faster, and be more efficient. We never talk about the invention of aircrafts. We never talk about the invention of television because all these were absolutely breakthrough technologies, you know, in those days. But whereas there's so much of hype about AI because it's actually it's nothing but assist to the designers who have their own thought process. We have so many senses. It's not that AI or any other technology has all kinds of senses which a human has. You know, like the tactile sense. Does AI has tactile sense?
So we can take it as a smart employee.
Yeah, it's a very good EA for you. I think what you can do is to remove the mundane activities which are repetitive in nature, where you actually invest time in doing things which are not so productive. So when you're sketching, for example, in design, you're making several sketches, which is the intellect of the designer. But when you're converting a sketch, which is the starting, the purest form of creation, into something which is more tangible, which is probably a render or a 3D model, that is where AI actually comes into picture, and it converts the sketch into a 3D model very, very quickly within seconds. Earlier, people used to take like a week for making a handmade render. Then you had 3D programs which could actually render the product very fast. And now it could be done in precisely 30 seconds, you know. So the input is actually coming from the human brain, whereas the whole rigmarole of making a render and putting in a whole lot of manual work is something which is being done by your assistant, which is AI. So I think it's just making design more agile. It also means that the access to design can be more democratized, which means it can reach more people faster and at a lower cost because you're not investing so much effort in doing or making or preparing this design over the whole cycle of the design process, you know. So I think AI is a fantastic tool like any other tool. I would equate it to Google or many software programs which just help you in making you agile. What it gives you extra is a little more interpretation of your thought and which is faster. So I don't think it's going to disrupt the human brain, but it's definitely going to disrupt the way things are made, the speed at which you can actually launch the products, and Detailing for which you invest too much time and many other tools could be done much faster. So probably, I think you will get better quality products at a faster speed.
So keeping that on note, let's come to Ms. Shalini ji. AI has a capability to generate dynamic branding elements like logos and packaging, जो अभी हम ऐसे बात कर रहे थे. Do you believe that Trademark Act, Copyright Act, Design Act is well equipped to address these evolving challenges, or is there an urgent need for legislative reinfringement?
I may be very biased, but I should share my views about this. I don't think the Copyright Act, the Design Act, or the Trademark Act is good enough even for the challenges before AI. I don't think it is doing justice completely, at least in India, and I speak from experience. Even in India, we've gone ahead, we have registered our designs have been copied, we have taken them to court. The court has given us a permanent injunction, but it just doesn't end there. What follows is endless series of dates, tarikh pe tarikh. We are a product design studio. Our core competence is design. We stay ahead of competition by designing. That means in a year, we may be designing upwards of 30, 50 objects. Now, if every object design had to be registered by us, it comes at a certain cost. Not all the designs that we register do well commercially. सब कुछ नहीं बिकता वैसे जैसे बिकना चाहिए. You have 1 or 2 or 3 best sellers which actually help you take your money out of the investments that you've made in that process. Now, to be forced to register your design and then go for protection once your design is violated, your rights are violated, and then get a permanent injunction and then keep appearing in court, spending money in legal fee to protect your design, where the opponents, the defendants, as was pointed out by Navdeep, will go back to court and question your design and challenge it to say it's not original. In the day of AI, it will become even more common because nothing that AI does will be original. AI learns from data sets of existing works. A lot of that work may be having copyright issues, but AI will still come forth and learn and produce results from there. So in the current context, if we are not equipped, AI is only going to make it more difficult. Before Navdeep's session and the interaction with the authors and the people in education here, I thought only the product designers and people who come under the Design Act have it hard. I am wiser now. I think anybody who is in the creative field has it equally hard, be it for copyright registration or trademarks or design. Design particularly, I'm still biased, has it hardest. Why? Because we can be covered under copyright, we can have copyright protection, but we don't because we end up producing more than 50 pieces, 50 units of that object, as Sir said that section 15(2) applies to us, that if a product which is capable of being registered under Designs Act, one goes and produces more than 50 pieces, it loses its rights of design if it is not registered. Again, the challenges of registration I've already shared with you, that you don't know how many of them will do succeed and will do well and earn you back the money, or it is just sunk cost. We as a company have gone ahead and challenged section 15(2) in the courts. So there is a writ petition we have filed, Mukul Goyal versus Union of India, wherein we have urged the authorities to write down section 15(2) so that product design also can avail full copyright protection without the need for registration. Cases like Rahul Mishra, which again Navdeep shared, is a fashion design brand. They do not need to sell, say, 50 or more pieces of high couture because those are high value items. They do 4 collections in a year: spring, summer, winter, autumn. They move on. They do it. So that whole industry survives on different collections. They sell high value stuff. But imagine the craftsmen of our country. Imagine all the people, the Dhokra artists, the Gond artists. They do smaller objects, they do low value products. They need to sell more than 50 pieces. They cannot keep designing new things every day so as to remain under the number of 50, so as to avail copyright protection, which in any case is not guaranteed. Because the courts are in any case very, very busy with, they have backlogs, we all know that. So I am talking from a very pained heart. I have spent enough money, time and resources in IPR protection for my company. I have learned a lot with Jaya. I'm very passionate about the subject, but I feel let down by the system. Today, I have only one design registration, which is in force. And that too, by 2029, that registration will also go. But my product design is here to stay. The product that we had designed in 1998 continues to be a good seller for me today. Why should I lose a design registration or design rights over that product after 15 years? A copyright allows the protection to last up to author's life plus 60 or 70 years. But a product design registration doesn't give me any validity after 15 years. So there's a lot of work which still needs to be done. AI will only make it more complicated. Again, because in AI, there are a lot more parties involved. There is a coder, a person who's writing the codes. So an OpenAI will have a lot of people who are writing their codes. OpenAI has employed those people. There'll be very serious contracts between companies who generate their own AI codes. Then there are companies which will have designers using those AIs to design products, ideas, thoughts, etc., using AI, which is created by another company, written by another guy. And that employee of that company must have a contract with even the employer to make sure that whatever is being created by that AI is belonging to the person who's paying the employee's salary. Having said that, once that product is designed or that item is designed, written, composed, there is really no certainty that it is original, that it is novel, because again, it is learning from a data set. AI cannot think on its own. AI depends on the prompts we give. And look at the catch-22 situation. When we give the prompts, the AI is learning from those prompts. AI is continuing to learn, but it'll still be behind human intelligence. But till the laws of our country are, spruced up to protect the designers, the creative community here, I don't think it's worth investing in design registration. I'm sorry, but I am not going to be investing more in design registrations now.
Now coming to Nishtha Sharma ji, मैम जैसा चल रहा है, शालिनी मैम ने बताया कि रिफॉर्म्स की सख्त ज़रूरत है. क्वेश्चन ऑलरेडी रेज हो चुका है कि ये सारी चीज़ें प्री AI एरा में बने हैं. So question for you is, the rapid evolution of AI calls for the proactive legal framework rather than a reactive one. What pivotal role can policymakers, legal scholars, and industry leaders play in ensuring that AI remains an enabler of innovation rather than a disruptor of existing legal structures?
Thank you. So, when we come to the policymakers and how the AI is working, AI has been around for around 50 years. It has already completed half a century, but it has gained all the buzz now. It's permeating so many industries, whether it's automobile design, and it has created so many questions. It's very true that all the laws were created in a pre-AI era. Copyright was in 1957, Designs Act was 2000. All of them are pre. In fact, the AI is, increasing rapidly. It is constantly evolving. As and when I'm talking, somebody is using AI. Right now, they're on ChatGPT giving a text prompt. So it's constantly learning, it's storing data. And the users, we don't know if the proper procedures have been followed. The companies are investing so much in innovating, in taking this technology to the next levels, but we don't know if the proper licensing have been obtained. So what can we really do at the end users? In the legal industry, the AI is interacting with all the industries, but in the legal industry, it's just given rise to a lot of questions regarding infringement, questions regarding originality, authorship. So it has just created a lot of debate all around the world in IP offices. It's the USPTO, whether it's WIPO, all of them are currently navigating what can be done. And the law takes time, as has been already pointed out. So it can be at times a frustrating process, but currently we don't even have a uniform nomenclature for what AI is. Largely, it is understood to be that it is mimicking human intelligence, but it's only performing certain specific tasks. So Google Predictive Search is a classic AI example. Facebook and how Netflix recommends movies to you, that is also AI. So it's constantly saving you. It is studying you. It is studying your behaviors and then responding to it. But why all the fuss now? Because now it is also generating content, which raises questions about what originality can really be. So when I was studying about it and researching more about it and how the design industry is seeing this, so there's a lot of, like Sir pointed out, Mr. Anuj Sir, he pointed out that, it's just a tool. So there can be three different point of views. From a legal point, we need to see that whether it's either design is generated by AI, it is assisted by AI, or how much of the human interaction was actually involved, how much skill was actually involved. So at the present, we don't even have a nomenclature. Like generated AI, from my point of view, it could be that something you are entirely relying, just a click of a button, you went to a GPT variant and you gave your command that, I want to create a new product and I would like to make it more appealing. So could you, on such and such, make a design which maybe has a picture of a dog that can be applied to a mug? In this case, my contribution was simply that I pushed a button. I'm not aware of the inner workings. I'm not aware how it came about to be, but that's just it. So it's entirely generated by AI. Does that mean that I have to credit the AI? Does it become the author? So, and now what could be AI assisted? Now, for example, if you're using tools like Canva and Adobe, you can use it to make designs better. Like Sir said, that you can use it to create different iterations. It used to be a tremendous task that you had to sketch it all out over a period of hours, and you have to actually put in the effort. But now you can just remodel everything and use it to create different designs and create different variations of it. And so there's one way in the design industry is embracing it, because it can take care of your administrative tasks, right? And you can actually really focus on the creative aspects of it. There's an interesting design AI chair which was designed by a designer. So what he did is that he used the AI to actually analyze the market, what would be the customer's preferences, what would be the best optimum custom level of comfort for a particular buyer. And his intellect was involved in choosing the colors and the design appeal of it. Now, from a legal point of view, who would you credit? Would you credit the designer? Would you credit the AI? Or would you credit the developer of the company? I'm sorry? Collaborative? No. So this is a question of authorship that we are, currently find at the battle of it. And by copyright law, patent law, and trademark law are all debating about potentials of AI infringement. Unfortunately, design law's interaction with AI is an uncharted territory, and there's a lot of debate that is yet to be required. We really need to revisit the laws. So, what the policymakers can really do is at the outset, we only have questions from the legal point of view. Currently, we don't have answers, but the debate is ongoing. So, let's see what comes of it in the coming.
Now we are open for questions. And if you have any questions, please ask. Please name the panelist as well. And if you have the question for the whole panel, you can also say that.
It's for the whole panel. At this stage in life, AI, along with all the developments that have happened so far, has kind of flattened the world. You earlier had medical experts, legal experts, design experts. We all had our expertise. Now with AI, design is being, prompted and results are obtained from AI very close, at least to most of the average design that comes out. Perhaps the industry, the clients don't care how it is obtained, what it means, because that's the state of most of the industry. Similarly, a lot of medical knowledge has come to a normal man, and we are able to solve some of these issues by ourselves. I guess it is the same with legal, etc. So what I see is the overall standards and knowledge of the world has arisen. Now we have to prepare ourselves for the future, all of us. How do we figure out what AI does? How can it be controlled for our benefits? For the benefit of all the kind of professions that exist. So I'd like each one of you to tell us how should we prepare for the future world, which means the world which is right now, the youngsters who are, the children and whoever is around us. Because for us, hamara to ho gaya. We are finished. We'll struggle throughout. But what about the future?
So the last statement which you made is made by every generation. It's not only you who said so. My father said the same thing to me. What will happen to you guys? Same as what we are saying. So it's an ongoing thing because it's evolution. Evolution is assisted by technologies which started from a wheel. That was also a technology, So to answer your question in very few words, it's a choice which we have to make whether we want to be masters or slaves. Can we master the technology or should we become the slaves of the technology?
So, for example, I also see there are some professions are more concerned than the other ones. Let's say design right now is being discussed and we have huge concerns. I don't know if the legal professions even bothered about it. They don't care what happens to us in the legality of how we are going to get over that. I don't know whether the policymakers are bothered about it. So you see, all of us are progressing about the same technology with at different times and perhaps with different levels of intentions. So what is it that we all can do about it? I mean, the design community is so small that even if we raise our voice, it doesn't reach beyond the 2 meters ahead of us. What can be done?
You want to answer?
I can speak for design community, even though I'm not a designer, but I am an integral part of the community, being part of the design studio. I think the community needs to be more aware. There are very few designers I know who are aware of their rights and the importance of protecting their rights. I mean, designers like Sabyasachi say, I like it when people copy my products. He can get away because he's a big name, he's made lots of money. One of his dresses will sell probably in a lot of money, more zeros than I care to count. He can afford to say that. He gets away by saying that, but in saying that, he dilutes the essence of the other people's rights. Not everybody can afford their products to be copied. There are a lot of other smaller fashion designers who are making products and the neighborhood tailor is copying, or the neighborhood lady is going to the tailor or getting it copied. What about them? It's time that each of us takes it seriously. This is our livelihood, this is our community. If we don't stand up for each other, nobody else will. Mukul Goel, my partner and husband, he put his own money in filing that writ petition against Government of India to review Section 15(2). He did it not only for his own personal gains, he did it also for the community. But the community is not aware of it. The community doesn't know about it. Even if when the design meets happen, IP is never discussed. We discuss so many other things about what things are going wrong, but we never discuss this. So maybe we should have a meeting, these kind of meetings and discussions within the community. We need to create more awareness to create a stronger voice. That's what is needed.
Anyone else? More questions?
Something regarding I think she mentioned that the legal profession is not doing anything about the AI. I'm not very sure whether I'm right here, but I just read, and I think there was a case where the courts have said no, this AI type of a design or a AI type of an court order is no more effective. So that I'll probably get back to you with that case also. So it is not that the legal profession is not doing anything, or the entire problem here is maybe it is only the medical profession is into the AI or the authors are into the AI. It's not so. So even the legal profession is into AI.
Okay, an important question which we have left for the panel. It's a very important question. I thought I will ask that in the end, if it is not coming in between. So, of course, abhi tak aaya nahi. So now I need to raise this question. This will be the last question from the side of the audience. Right now, I'm not the moderator. I'm the audience myself. Need to ask one thing, that copyright itself is a criminal offense. It comes under that, right? But design right criminal offense के अंदर नहीं आता है. So क्या एक इस चीज में रिफॉर्म की रिक्वायरमेंट है, बिकॉज नोवेल्टी और क्रिएटिविटी तो उसमें भी उतनी ही लगती है. And दूसरा, if designs are not covered under criminal offenses, then can we, when we submit our designs for the registrations, जो मैम ने यहाँ पे mention की बात sketches की, जो भी sketches में possibility हो सकती है, of course sculpture उसमें नहीं आ सकता है, लेकिन एक sculptor का जो sketch है, उस sketch पे अगर हम copyright लिया जाए तो उस पे एक criminal offense की धारा बनाई जा सकती है, right मैम? So can be taken as a solution? No.
See, ये हम फिर जुगाड़ ही कर रहे हैं ना.
She asked for the help of legal professionals.
Rahul Mishra की product should have been registered design, but they hadn't because उनको 50 से ज़्यादा बेचनी नहीं होती. So they got protection under copyright, right?
Yes.
जुगाड़
है ना?
So इतने loopholes क्यों हैं?
Anybody like to answer, sir, ma'am? Anyone?
ये मैम जो बता रही है अपने एक्सपीरियंस से बता रहे हैं.
Ma'am right now is being the orator of IP community. She is representing the whole IP community and she is making a very valid point. Sir has also made, Anu sir also made the valid point concerning the future.
Every authority has its own role, like IP office. Their job is to register the intellectual property. Okay, the courts have different role, enforcement, and so if the courts, courts of cases are pending, so it is the duty of the government to provide the right person and number of required persons. Now, like police. How many? I think 1 lakh people, there is one policeman over 1 lakh person in India. So it is the infrastructure the government has to put in place, and everybody has its own role. So like IP, when I was 37 years back, I saw this patents designs were granted after 7 years, 8 years. Then slowly government, upgraded the infrastructure, increased the manpower. Now you can get patent even 100 days or even 3, at least normal now 3 years. So slowly things will change. Jugaad can't be a solution. It has to be a regular upgradation of the things. तो AI से आपको डरने की जरूरत है. Lawyers work will be reduced because you will be able to draft your plaint in short time. You will be able to draft patent specification at least 60%, 70% through AI. So AI is going to reduce your time drastically.
Reduce our time or reduce us?
Sir, really?
No, reduce your time. Reduce your time.
मैं आपका एक जवाब देना चाहता
Sir, I
हूँ.
wish you were right there.
In the hierarchy of things, when there are court cases which are pending of murders, disputes, then design comes in at such a lower hierarchy कि उसका नंबर ही नहीं आ रहा सर.
Ma'am, we have specific codes for copyright.
I think
So we have specific codes. You cannot say that a criminal court will take on a intellectual property case. That code, that bench is absolutely different.
map
So for you to say that will be wrong. ma'am.
short while ago, I already explained that the government, I mean the high courts now, the four metro cities high court, they have a separate IP division. I'm sure in the coming time you will find IP division in all high courts. So slowly there's a infrastructure upgradation and we'll find that the disputes are resolved quickly. And I think so. The decisions are now with the specialized judges are more practical and reasonable.
Okay, Anand sir, you have something to say.
जो आपने सवाल पूछा ना कि it is not a criminal offense, तो क्या डिजाइन कॉपी करना क्रिमिनल ऑफेंस होना चाहिए कि नहीं होना चाहिए, इसका जवाब दे रहा हूँ कि पहली बात तो ये कि we as designers cannot be too possessive about our design because there's so many creators all over the world, they are creating similar things also and stuff is happening. But to me, I always feel that if there is some infringement on design which happens, it actually helps you in evolving your own thought process. Suppose it's a criminal offense, you have created a design, nobody can ever copy it, you are complacent with it, no? You're happily sitting behind it. कुछ और करने की जरूरत ही नहीं है, isn't it?
सही बात है.
AI के जमाने
निष्ठा जी प्लीज हम निष्ठा जी एक कह रही फिर उसके बाद एक टेक योर वर्ड्स मैम.
AI के जमाने में आप किसके ऊपर क्रिमिनल ऑफेंस लगाओगे? When the work has been generated by it, who will you hold liable? That was a very interesting question.
Agreed ma'am, please.
So I disagree with Anuj. I'm not debating here ki whether it should be a criminal offense or not. Going back to the photocopy case, whether the rights of the authors were being violated because parts of their books were being photocopied is still debatable. It's still, there are unanswered questions there. In my company, we have over 80 people working for us. That is 80 households. The moment my designs are copied, that means I'm selling less of my products because there's somebody out there who's copying my designs and selling cheaper products or whatever. My business is impacted. That impacts the livelihoods of all those people. Okay, tell me, is it a criminal offense or not? Don't look at only design, look at the livelihoods, look at what it's impacting. On one end, the government says create more jobs. Here I am, creating more jobs. But I am not able to do the right business. I'm not able to pay them well. I'm not able to protect my right. I'm not able to grow my business. So this employment that I'm providing is really not fruitful because how will I give the raises if my business doesn't do well? So I don't want to answer whether it should be a criminal offense or not. I want everybody to take it as seriously as that. I don't want people to go behind jail.
You have a question?
मेरा जो क्वेश्चन है,
Please make it quick,
हाँ मेरा जो क्वेश्चन है शालिनी मैम के सपोर्ट में है कि ब्रेड की चोरी करते हैं तो चोरी का इल्जाम लगता है, 1000 रुपये की चोरी करते हैं तो चोरी का इल्जाम लगता है, 2 करोड़ की चोरी करते हैं तो चोरी का इल्जाम लगता है. तो किसी की क्रिएशन और इंटेलेक्ट को चोरी करने पे चोरी का इल्जाम क्यों नहीं लगता है?
बिल्कुल सही बात है, बिल्कुल सही बात है. There should be a round of applause for this because this is an important issue. यहाँ पे हम सब, मैम ने CPNIP, ma'am gave us the opportunity to discuss this. This is what the platforms are that legal professionals are making difference so that we can have a discussion, right? You guys are much more important because you have taken out your Saturday important. And coming over here and listening this boring lecture, and now it is an interesting one, I would say, right? So this is important that government should think over it. You have one question over there?
I just actually wanted to add to Kunal.
Okay.
What he said makes sense, but if I look at it another way, if I say that lawyers, frame arguments and file applications and so on and so forth, and by the end of the day, the judges go and author the judgment. So it is essentially our intellect that they are using in their judgments. Just saying, just putting it out there. I'm not going to do anything about it.
Okay.
But ma'am, to your point, I feel in today's day and age, what brands do essentially, what I understand, I could be absolutely wrong, is when they design a product, they make sure that they monetize it and sell it hard and fast in whichever manner possible to gain. That is why that 15-year clause is there. So if you can do it in that 15 years, I think that's a big enough period. I'm arguing from the other side per se. I think that the 15-year period is big enough for you to monetize it and to take it to a level that other players don't matter to you after that 15-year period. I mean, best of the brands are being copied today, ma'am, all around the world.
But the point is, who decides 15 years? I haven't made enough money yet. Okay? My product that I first designed continues to sell very well even after 28 or 27, 28 years. Who decides 15 years for me? Copyright. Copyright, you don't get that limit.
Sir, it is the voice of an experienced litigant. We cannot fight with that.
See, let me give a perspective. She runs a company which is into design and manufacturing. I run a company which is into design and consultancy, which means that my job is to give designs to the customers. And
Sir can design from automotive to a jar, anything, from A to Z. That's a big deal.
Sumni, what I'm trying to say is I'm just trying to set the context that, see, we always talk about that innovation has to be a constant, it has to be constantly done, which means you always keep innovating. And why do you keep innovating? To become better than your own self. That's the best thing to do. But then you also want to become better than the competition, And what is competition doing? In a country like Japan, for example, Sony was the innovator and Panasonic was the follower. In the same country, two big brands,
Yes.
So Panasonic never made an effort to be the disruptor in the market by creating new things, but they always followed. Who created the market size? Sony. And who actually leveraged the market was Panasonic. And Panasonic's turnover, I'm sure, would be as much or much more than Sony. Now, this is a traction which is very important. Traction, which means a pull. And pull or a tension actually creates a lot of energy, And that's the reason it's a constant endeavor. If we think that nobody can copy and 100% protection can happen, no. We definitely need to protect ourselves, but we also need to take it for granted it's bound to happen, and for which we need to have our own strategy of constantly innovating, and there has to be a pipeline of innovation which has to be built in, and which is what most of the big companies do. They build up a strategy to keep innovating, keep introducing new things, because they know however much muscle power they have financially to combat the plagiarism or copying the products, still they can never ever overcome it, because it's a nature's law to do it. So you need to protect yourself, but at the same time you also need to be always innovating, always doing new things.
Thank you so much, sir. A big round of applause for this wonderful panel.
लॉ स्ट्रीट भारत, राष्ट्र के हित में।